This is the craziest thing. At a networking charity event, what happens if I run into the defense's medical expert and now he approaches me and wants to talk to me about your case? Can I talk to him? Do I have to tell anybody about it? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. So now, this is a medical malpractice case. You brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your injury. And now the defense refuses to acknowledge they did anything wrong. And now that means that you're going to trial. So after 2 hard-fought years of litigation, your case is finally coming up for trial, and it's scheduled for the next few weeks down the road. Now, before that happens, I'm at a charity networking event, and who do I see? I see the defense's medical expert, and he makes a beeline right for me. Now, how do I know that this is the defense's medical expert? I'll tell you how I know. The defense has an obligation to notify me that they're bringing in certain medical experts. So now we don't tell the other side who we actually hired, so we give them all of the doctor's qualifications, including where he went to school, where he did his residency training, if he did a fellowship, if he's licensed in this state, where he's licensed, as well as what his board certification is. That's a requirement, and of course, if he's published anywhere in the medical field. Likewise, we have to do the same thing. But what's interesting is that now we take that information, we plug it into a computer program, it spits out the name of the expert, and then we go ahead and try and dig up any dirt on this particular expert. So now, let's say I know this expert. I know him because I've cross-examined him before. I know him because he's in the legal community. He represents a lot of doctors or testifies for a lot of doctors and hospitals. So I've seen him before. And now, during the course of this networking event, he sees me, he makes a beeline over to me, and he introduces himself. Hey, Mr. Oginski, I just want to introduce myself. I'm Dr. Jones. Yes, doctor, I know who you are. And now he starts talking to me and he says, listen, I'm testifying in this case that you represent this injured patient, and it's coming up in a couple of weeks. Hey, I wanted to talk to you about it. Really? What do you want to talk about, doctor? And now he starts telling me information, or he starts asking me questions such as, how is it possible that your expert can confirm that there was a violation from the standard of care, that something was done wrong? And now maybe we get into the conversation. Now maybe we get into the details of your case, of the merits of your case. And you might be asking yourself, is this appropriate? Is this proper? Is this ethical? Can I have such a discussion with the doctor for the defense, the medical expert who's coming in to testify against us? Well, there's no clear-cut answer. Some attorneys would likely argue that it is improper, it is unethical to have a conversation with the defense's medical expert at some networking event to talk about the details of your case because you have opposing interests. On the other hand, there are some attorneys who say, no, let me talk to the doctor, let me see if I can extract some useful information that I can now use at the time of trial when I get up and cross-examine this doctor. That's an interesting strategy. Likewise, if I say something that's detrimental to our case, if I reveal something that is unflattering or a weakness in our case, you can be 100% sure that this doctor, this medical expert, is going to go back and tell the defense lawyer about that particular conversation and about that weakness in our case. And this is how it happens. So now the case comes up for trial. The defense lawyer calls this medical expert to testify. And now during his questioning, he says, hey, Dr. Jones, isn't it true that 3 weeks ago you ran into Mr. Oginski, the plaintiff's attorney, at this networking charity event? Yes, I did. And during the course of that conversation, isn't it true that he approached you to talk about this case? Yes, he did. Now, I'm beginning to get steam coming out of my ears. And during that conversation, isn't it true that Mr. Oginski revealed a weakness in this case? Objection, Judge! And now the judge will have to rule on this objection about whether or not he can talk about that particular conversation and the details within it. And you know what? The judge is going to let him talk about that conversation because we did, in fact, have a conversation. So now, assuming, of course, that I did reveal a weakness in the case, the defense lawyer is going to ask this medical expert, hey, Dr. Jones, what was it that Mr. Oginski told you was the biggest weakness in this case? Oh, Oginski said that they were very weak on liability, that they really couldn't prove that there was a violation from the standard of care, or something like that. Right? And now what does that mean? That means the jury is going to recognize, number one, that I was the aggressor, according to this doctor, and number two, that I revealed a weakness that we really don't have a valid case. That's a significant, significant problem. So now what have I done? I've opened up a whole Pandora's box, something that I never wanted to happen. all because this doctor approached me and started talking to me about the merits of your case. And in thinking that we're having a great conversation, a casual conversation, now I open up and I reveal a weakness to him. Well, guess what? That weakness can come back to bite us in the butt, because this doctor is going to go back and start blabbing to the defense lawyer, who's now going to use it at trial to show that we don't have a valid case. Likewise, if the doctor revealed something to me that was unflattering or exhibited a weakness in their particular defense, you better be sure I'm going to use that information when I cross-examine him at trial. Doctor, isn't it true you and I met 3 weeks ago, inadvertently? We were both at a networking charity event, isn't that true? Yes. And during the course of that event, you came over to me to say hello, isn't that true? Yes. In fact, you introduced yourself, true? Yes. And during the course of that conversation, you told me that you would be coming in to testify on behalf of the doctor in this lawsuit, isn't that true? Yes. And during that conversation, you revealed to me, number one, that you didn't have a defense, that you were trying to overcome our claims that there was something done wrong, isn't that true? Oh, no. Whatever he says, now I'm going to use against him. And now the doctor has to try and defend against that cross-examination tactic. So is it appropriate? Is it ethical? Do we have an obligation to tell anybody? I would argue that no, I don't have an obligation to tell the defense lawyer that I met this doctor before trial. I would also argue that I don't have an obligation to notify the trial judge that I had a conversation with a medical expert a few weeks before the trial. So where there's no clear-cut yes or no, the better practice is don't even get involved with a conversation with the medical expert. Simply say, hey, doctor, listen, nice to meet you, but I can't talk to you about this case or anything else. I'm more than happy to chat with you after the case is over. So why do I share this quick information with you? I share it with you just to give you an inside look at what goes on, what could happen, and what has happened in some very rare instances in cases involving medical malpractice here in New York. You know, I understand you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're getting bitten up by all the mosquitoes out here, no, seriously, if your matter did happen here in New York and you have not yet started a lawsuit because you still have questions that need to be answered, then what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.